Apologies, Judge. All right, good afternoon, everyone again. This application hearing is in the matter of case number CFI 020-2023 and is being held by way of video conference before Justice Wayne Martin, appearing from Australia. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by NHB Legal, lead counsel Mr. Amr Jamal. The defendant is ELINX INFOTECH LLC, represented by its CEO, Mr. Asad Khan. Will the parties and the judge please confirm that the situation is as I have stated?
Well, it's almost right, Saeed, except that I'm in Hong Kong, not in Australia at the moment, but that doesn't matter. But otherwise, it's fine.
Safe travels.
Okay, yes. And counsel,
Could
you
ask
confirm that
for the claimant.
Information is correct? Mr.
Correct
Khan?
for the claimant, correct?
Yes, thank you. Mr. Khan?
Yes, that's right.
correct.
As per the defendants, yes, correct.
Right.
Thank you.
Thank you. All right. Thank you, Saeed, for that introduction. Mr. Khan, it's your application. Would you like to start?
Yes, please. So, thank you for giving me this opportunity to come here and present my side of the case. In this application that was filed, it was based on the false facts that were represented by the claimant. And the false facts were very simply that we have a contract in place, and the contract is black and white, it's in writing, and they have falsely mentioned that there is a refund clause for the entire agreement, whereas the refund clause is only for a very small amount of the contract, maybe probably 20% of the contract. But the claimant has falsely mentioned that it is for the entire contract, 100% of the contract value. Secondly, the similar case was tried in the small claims tribunal last year, and exactly the same facts were presented, and there was nothing that's changed, and there also the judgment was in the favor of the defendant, that is us. Uh, 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 Moreover, I mean, they filed an appeal, and the appeal was also rejected on this very same reasons. We have all the supporting documents and evidence for the case. We have completed our part of the work. We have produced work done certificates signed by the claimant and the team. So there is absolutely no reason for this claim to, come to the CFI. Also, they have blown up the value of the contract by adding a third party software that was implemented after after our software, just to sort of increase the value to above 500,000. They have qualified in CFI, and they're making the claim against us. So these are some of the facts. There were three parties in the contracts. The payments were made to the third party, and they have sort of absolved the third party of all the charges as well. So all in all, all the facts.
Sorry, why do you say they've absolved the third party? They've discontinued against the third party because the third party is that is the second defendant.
That's right.
It's in liquidation. So I assume that the view has been taken there's no point in proceeding against that. So I don't understand what your argument is in relation to that.
In relation to that, the reason is that, I mean, all the payments were made to the second party, and what probably the first party received is very small amount of the claim, and probably and they have not even submitted any of the submitted any of the proof of payments done to the first party. So the entire claim amount was actually made to the second defendant. And the second defendant.
Sorry, just interrupt and apologise again. But sure. Then in terms of the remuneration of the first defendant, that was a matter for agreement between you and the second defendant, wasn't it?
So the whole point here was the second defendant, when they actually were the part of this case, they were actually representing and leading this case. and they had a legal team because they're a big group of companies, and they had a legal team who was representing us and them together. And eventually, we got to know that after they were absolved, the defense as well was not even the defense was not filed, and this delayed the entire process. So all in all, I think this had led to the first defendant's delays as well in the case. So then that's when we actually got involved, and we made the application. We filed our defense as well as acknowledgement of service. That was the time, and then we presented all the facts that were related to the case. First of all, the work was completed. We have proof of work done certificates. Also, the claimant has made thousands and thousands of entries in a software in the last 2 years. In fact, even if one software, one JV, one receipt issued to their customer from our software, if they have used it and they've issued this contract or receipt to the customer, that itself proves that the license of our software was used and our intellectual property was used, and therefore they have complete obligation to pay. So there is no reason. I mean, what
Except
the whole
but Mr. Khan, they say that the software is deficient and that it won't produce the services that you warranted it would produce. That won't produce trial balances that are reliable. That's what they say. What do you say to that?
But sir, if thousands and thousands of receipts, contract, and invoices and customer statements were issued to their customers, I mean, the customers would have made such a big, if anything was false, the customer would have made a big issue out of this. I mean, no customer would accept, 100,000 dirhams of contract or 200,000 dirhams of contracts coming out of system, which is false. And if any mismatches were there, obviously, I mean, that would have shown. But they waited for 2 years, and then they
But
filed this
just
claim.
again, I'm sorry for interrupting. Just pausing there. Is there a difference though between what I might call use of the software for delivery of things like invoices to customers on the one hand, and the internal accounting software used by the claimant for its own purposes to produce, for example, trial balances and accounts and reports and things of that sort?
Yeah.
Is there a difference between those aspects of the software that was supplied?
So it's a completely integrated one module. So there is no relation, no integration with other modules. So what happens is the moment they raise an invoice, it debits the tenant and credits the revenue. It's very simple. The moment they create a receipt, then it basically debits the bank and credits the tenant. And that's how the tenant's balance becomes zero. And this aspect is completely functional, 100% correct. There's no problem. In fact, I have also attached the screenshots of the trial balance, which shows the trial balance is tallying. And if at all, see, trial balance again is nothing but an output from the system. So if there was any discrepancy in the report, we could have easily rectified it. But the most of it, the entire software you use, the leasing software was used, the facilities management software was used, the CRM software was used, and it's a complete ERP that's in question. And even in finance, you have general vouchers, payment vouchers, receipt vouchers. So all those modules were used. And if you evaluate the software, there are thousands and thousands of entries. I mean, if in just in the first 3 months uh, of use, if there was deficiency, easily that could have been identified, and that's a reasonable time frame to ask for cancellation of contract or termination of contract. But after 3 months pass by, even we have consumer rights. I mean, like after 3 months pass by, how can anybody claim for termination? Because we have paid salaries, we have incurred expenses on this entire project, and I cannot tell my employees that we have paid you salaries and please, the customer wants to cancel the contract, refund your salaries. That's not the right way. They waited for 2 years and they make a claim. That itself shows that there's something wrong. You make one JV, it doesn't balance, it'll show in the trial balance. You pass a few entries, 1 month, 2 months, 3 months, hundreds of entries, it would have shown a deficiency. That was the time to ask for cancellation, not wait after waiting for 2 years and then ask for cancellation. That's absolutely illogical in our opinion in the software world. I mean, not only that, they waited after completion of 1 year. There is something called annual maintenance and support. They even renewed the support contract. So they paid for it. They renewed the support contract, not just one support contract, but two support contracts they renewed. So that's again, I think, point to be. It's a very important point to note that the software is absolutely functional. No customer would ever pay for support contract if the software has deficiencies. They would not incur more expenses. There were milestone based. There were milestone based payments, and these milestones were also, uh, completed on time, and payments were made according to that. Mind you, the payments were made to the second defendant, and all the logical steps were completed, and they were acknowledged by the claimant. And after that, question of termination is just beyond any reasoning, in my opinion. So that's all from my side, Your Honor.
Right. Thank you, Mr. Khan. Mr. Bajamal.
Thank you, Your Honor. I trust that Your Honor had the chance to read my skeleton.
I have. I've read the skeleton. Yes, I've read the skeleton and all the attachments, Mr. Bajamal, and I've also read the recent filing of the references in the rules of court, to which you wish that you might want to take me to.
Thank you very much. Your Honor, just as a housekeeping matter, because we don't have the benefit of the electronic bundle today due to the technical issues with the court's portal, so we're relying on the PDF. So I am working from a hard copy, which is identical to the one you have.
Right. Well, I've got an electronic copy, so if you want to take me to, if you can just give me the page numbers, I can navigate quite quickly through the electronic copy.
Perfect. Your Honor, I'd like to our primary position in this application. This application in our submission cannot be treated as a Part 24 application to begin with, because the RDC rules require that certain conditions be met in order for an application to be even considered as a Part 24 application for an immediate judgment. Unfortunately, what has happened in this application is that all of these conditions were not satisfied, and I'll take you through them one by one. The first rule that was not followed by the applicant is RDC 24.7, which states that the application notice must include a statement that it is an application for immediate judgment made under Part 24. If I may ask Your Honor to go to page 19 of the bundle.
Yes.
So on page 19, we have the application notice of the defendant for this application. And if we look at the middle of the page where it says application type, we see that it says it's an application for a court order without specifying which type of order, without specifying under which rule. And then if we go to the section where it says Part A, where it says applicant intends to apply for an order that, and then it says dismisses the claim, again without reference to what, and then in the description it says baseless claim with false information provided, same case was tried last year and the hearing was against the claimant reference case. The issue here is that when the claimant received this application notice, we were really wondering what type of application is this, and we had difficulties in identifying how to deal with it. So at the time we raised this issue to the registry, and because we noticed that the registry had treated it as a Part 24 application. We raised this by way of email, and the answer that we received at the time was that this is a matter for the judge to deal with later on. Hence, we are raising it to Your Honor. The second issue with this application is the violation of RDC 24.8, which states that the application must state concisely any point of law or provision in a document in which the applicant relies, or state that it is made because the applicant believes that on the evidence that the respondent has no real prospect of succeeding on the claim or the issue. Again, we are now speaking of the Part 24 rules because the application was treated by the registry as a Part 24 application. So that was the only choice we had. However, primarily on the face of the document, this was not a Part 24 application. The third issue with the application itself is again the failure to comply with rule RDC 24.9. RDC 24.9 requires every application under Part 24 to comply with Part 23. And RDC 23.25 provides that every application must be supported by written evidence and a draft order. Now, if we go to pages 21 to 44, I'm not going to trouble in order to go through each one of them, but if we look at these pages were the annexes to the application notice, and none of them include a witness statement, and they don't include a draft order. In essence, this is a violation of RDC's rules 23.34 and 23.35. Because the written evidence was submitted without a witness statement and without a statement of truth, as far as the RDC rules are concerned, this evidence, these sets of documents do not exist because they were not filed along with a witness statement as per the rules. Therefore, we say that this application should fail on the face of the document. We do not need to go into the merits as to whether the applicant satisfies the conditions under Part 24, and that the court should dismiss this application because it is not a Part 24 application. So that's our primary position. I'll move on now to addressing the Part 24 test,
Yes.
assuming that the court is not minded to agree with me on the primary
Mr.
position.
Bajmal, I think I'll hear all the arguments, I think, because I mean, the problem with dismissing it on what I might call technical grounds for non-compliance with the rules is that Mr. Khan could then make another application, having complied with the rules. And I think if there is, it's better for me to deal with it. If I can deal with it substantively on the merits, I think it's better for me to do so. So I'd like to hear you on the substantive merits of the application as well.
Sure. If we move to the merits of the application, again, we have found difficulties in identifying how Mr. Khan intended to address the test, because even his skeleton argument does not address the test. However, we've tried to summarize from his submissions three main grounds.
So you're breaking up, Mr. Bajmal. I'm sorry, I can't hear you. I can't hear you. I can't hear you, I'm afraid.
And how about now?
That's better. Thank you.
Thank you. So the first ground that we were able to identify from the applicant's submissions is there are three grounds. So the first ground, and I quote, it says that the claim is baseless with false information provided. And then the second ground is that the same case was tried last year. And then the third ground is that the applicant, that the money was paid to the second defendant. So I'll try to deal with each one of these grounds separately. So the first ground was not supported by any evidence. We know that the applicant acknowledges that there was a contractual relationship between the applicant and Muzoon. The applicant's position is that they have performed their obligations under that contract and that there was no breach. So that's a substantive position that can be addressed at trial. However, there is no connection between the test under Part 24 and this ground, because Part 24 requires an application for immediate judgment to establish that either that there's no real prospect for the success, or that there's no other compelling reason for the matter to proceed at trial. So the first ground is completely irrelevant to the test under Part 24. Secondly, with regards to the question of the decision by the Small Claims Tribunal last year, so we have interpreted this as a pleading that there's res judicata on the issue, and that the decision by the Small Claims Tribunal has dealt with the matter in a way that creates a buffer from. Now, if
I'm afraid you're breaking up again, Mr.
to
Bajamal. So I missed that. I wonder if you could repeat what you just said. You're breaking up again.
Yes. I would like to take Your Honor to the decision of the. I'm dealing with the res judicata argument, yes. And our primary position on this is that in order for res judicata to attract, the cause of action under it needs to be the same. And we say that the cause of action is not the same in this case, because the first claim was for termination of the contract and refund for failure to complete the project, the delivery of the project, whilst this claim is with regards to seeking compensation as a result of breach, a subsequent breach of that contract in the form of the 8 breaches that are identified in the particulars of claim. I would like to take Your Honor to the relevant part of the SCT judgment. That's on page 102 of the bundle.
Yes, I have that. Thank you.
So if we look at paragraph 26 and paragraph 27 of the judgment, here we see the judge describing the claim. In paragraph 26, the judge states the following: the defendant has submitted a certificate dated the 11th of November 2019, which is signed by both parties for the completion of the installation, and subsequently the second invoice dated the 21st of November 2019 fell due upon completion of the system installation on the server in accordance with the payment plan. The agreement fails to specify any further conditions that would need to be met prior to the second payment becoming due. And then in paragraph 27, the judge adds, nevertheless, the claimant claims a refund of the paid amount based on clause 2.6 of the agreement, as stated in paragraph 9 of this judgment. The refund referred to in this clause is further specified in clause 2.4 of the agreement, which reads as follows, and then there's a quote of the clause, which reads as follows: in the event of the software development not being completed by the service provider for any reason, the service provider guarantees on the company part of the amount paid towards the purchase of the 3 softwares. Essentially, the claim here was for failure to complete the project. And then if we move to the next page at 103, in the second sentence of paragraph 30, we see the findings of the SCT judge, and it says, as stated above, the fees were not paid in full by the claimant. Therefore, I find that a refund based on clause 2.4 of the agreement is not justified. Based on this, we say that it is clear that the claim was entirely different. The findings of the SCT judge were based solely on the question as to whether there is a justification for refund under clause 2.4 of the agreement, and the judge found that. That is the extent of the judgment, and it does not touch on any issues of compensation. It does not touch on any issues of breaches that that occurred at the time after the SCT proceedings, which in our evidence, we have submitted a witness statement from Mr. Screenshots from the software as recent as January 2023, which show that fundamental elements of the financial reporting aspect of the software were not working. So that is a fresh claim that is resting on a fresh set of facts that deserves to be investigated at trial. The last issue that Mr. Khan raised was with regards to the payment. And it is interesting that this argument is being raised at this point because the applicant never raised this issue during the SCT proceedings. In fact, even to this court in this application, Mr. Khan alleged that there's only $20,000 owed under the contract. In essence, this is an admission that the funds that were paid did satisfy the fees that were under the work that was performed under the contract. There was an arrangement between the defendant and the second defendant at the time. So there was never a question of failure to pay raised before, and therefore it is completely irrelevant for this to be raised at this stage, especially in the context of an application for immediate judgment. The last issue that I'd like to address with Your Honor is also a few observations I made from Mr. Khan's skeleton. On that, I would like to draw Your Honor's attention to paragraph 3 of Mr. Khan's skeleton. In paragraph 3, it is alleged that all the obligations were performed with the agreement. Again, we say that this is the evidence that there is an issue to be tried because there is a dispute between the parties as to whether the services were performed and whether the software is fit for purpose. Also, in paragraph 4.2 of his skeleton, Mr. Khan states that the signing of the annual maintenance contracts and subsequent payments is evidence that the software implementation was successfully completed and that it was operational. So we say that this is again another admission that the only evidence that the AMCs stand for is that the project was completed, and we are not disputing this this element, and this is the element that was the subject matter of the SCT judgment. What the skeleton fails to address is how the fresh breaches do not warrant a fresh trial. That is my submissions to an end, unless I have unless you, Lorna, has any other questions. We have provided a list of authorities, and I just refer to them.
Thank you, Mr. Bajmal. Mr. Khan, do you have any submissions in response? I can't hear you. You must be on mute, I think.
Yes, I was on mute. Sorry about that. Yeah. So of course, I mean, Mr. Bajamal clearly mentioned the 2.4 clause of the contract, which is the main original document between all the parties, and the 2.4 contract states very, very clearly that there are two aspects of the software that were developed. One is the standard product, which is used for real estate industry, where we have hundreds and hundreds of customers already using it. Top 4 big firm auditors have audited those softwares. Their trial balance is matching, contracts issued, the software is functional, and this can be vouched by these hundreds and hundreds of our customers who are already using it. We are not developing that software from scratch. And the other aspect was the development of some specific project management and architectural module for the claimant. And the refund clause was entirely subjected to those particular softwares, not for the entire agreement. I mean, Mr. Bajamal repeated the clause just now, the 2.4 clause, and based on which the SCT, court has, awarded the judgment in our favor. So, I mean, it's extremely clear. So, what is the basis? What is the basis of this new case all over again? And new case, just to qualify in the CFI, they have blown up the value above 500,000 by adding a third-party, software which the claimant has purchased. Just because of that, and which has no reference, absolutely no reference in our original contract. So that's what I would like to counter. And secondly, again, I would like to remind Mr. Bajamal that the claimant has made, as I said, thousands and thousands of entries. If the software was deficient, this would have turned out in the first month, second month, third month. I would even give 6 months, but not after 2 years of using the software. I mean, this has to be something seriously wrong with the claimant to come up with a refund and termination after 2 years. This is absolutely illogical. And as I said before, even before the claimant purchased the software, we demonstrated the software to the fullest. We had series of workshops to show how the software performed. And after that, the claimant proceeded to purchase the software. This was, as I said, not a software development from the scratch. It's a ready-to-use real estate software for the industries where we have hundreds and hundreds of customers who are already using it. And their CFOs, their auditors, big firm auditors have already audited the software. And absolutely, they've not found any deficiency. So this is what I would like to just remind Mr. Bajamal, that this is the situation.
Good.
Thank you.
All right. Thank you, Mr. Khan. All right. Well, thank you, gentlemen, both for your submissions. I'll give reasons for the view that I have formed, having listened carefully to your arguments and having read all the papers that you have helpfully filed. And those reasons are: this is an application for immediate judgment pursuant to Part 24 of the rules of the court. And in particular, Part 24.1 provides that the court may give immediate judgment against a claimant or defendant on the whole of a claim, part of a claim, or on a particular issue, if it considers that the claimant has no real prospect of succeeding on the claim or issue, or there is no other compelling reason why the case or issue should be disposed of at a trial. And the first defendant contends that that provision applies because it argues that the claimant has no real prospect of succeeding on the claim or issue, and I assume that there is no other compelling reason why the case or issue should be disposed of at a trial. The claimant, on the other hand, submits that this application is defective and that the various prerequisites of such an application specified by Part 24 of the rules of the court have not been satisfied. And Mr. Bajmal has helpfully taken me through those provisions of the rule which he says have not been satisfied, as a result of which he says the court should not treat this as an application for immediate judgment under Part 24. It seems to me that there is considerable force in the argument which Mr. Bajmal advances in relation to the failure of the applicant to satisfy the various preconditions to the bringing of an application under Part 24. But it also seems to me that if I can dispose of the application on the merits, it is preferable to take that course rather than leave open the prospect that there might be another application, this time complying with the conditions which the rules specify in relation to applications of this kind. So I will proceed to deal with the application on the merits, and the best way of dealing with that, I think, is by reference to the helpful skeleton argument which the first defendant has filed in support of its application, and run through the arguments that have been advanced for the purpose of trying to satisfy the court that there is no realistic prospect of the claim succeeding. In that regard, Mr. Bajmal's helpfully referred me in his skeleton to the authorities on the test that must be satisfied. They're quite well known. The authorities established that before the power to dismiss a claim can be exercised, it must be established that there is no real prospect of success. What that means is that the issue that the court must assess is whether the prospects of success are realistic as compared to merely fanciful. And it's well established again by the authorities that the hurdle that a claimant must get over in order to avoid immediate judgment is to show something a little more than a merely arguable case. In other words, the claimant must establish that there is a realistic prospect of success. And so that's the criteria that it will apply in assessing this application. Now, running through the skeleton in order, the first argument is that, as it's put in the skeleton, is that the claim is based upon a false statement or a baseless claim. And it's said to be baseless because the first defendant apprehends that the claim is for a refund under a specific clause of the agreement between the claimant, the first defendant, and the party who was previously the second defendant before that party was liquidated and after that dropped from the proceedings. There is a provision, clause 2.4 of that agreement, which refers to the provision of additional modules of the software and makes provision for refund in the event that those modules weren't applied. And first defendant says that clause doesn't apply and therefore the claim is baseless. The problem with that argument is that it misconstrues the nature of the claim. The first claim that was brought by the claimant against the first defendant in the Small Claims Tribunal was a claim under clause 2.4. It was a claim for refund and it was a claim for termination of the contract. Both of those claims failed because the Small Claims Tribunal held that the refund provision only applied to a failure to complete the agreement. It didn't apply to, if you like, breach of the agreement. It only applied in a circumstance in which some of the modules that were to be provided were not in fact provided, in which case there was a contractual entitlement to a refund of part of the purchase price. The Small Claims Tribunal held that those provisions weren't enlivened in the circumstances established by the evidence. Now, that is not the claim that is being brought by these proceedings. The claim that is being brought by these proceedings is a claim for damages for breach on the basis that the services that were provided were not of the kind that the contract required to be provided. In other words, the services were deficient and didn't fulfill the purpose for which the services were acquired. And that is a claim different in nature to a claim for contractual refund, or for that matter, a claim for termination of the agreement. Rather, this is a claim for damages for breach, and it's different, therefore, in character. So for those reasons, I don't think it can be said that the claim is based on a false statement or is baseless. The next argument that's advanced is that the argument that on the facts, the first defendant has performed its obligations in full and there has been no breach. And that, I think, correctly characterises the claim, because it does address the issue that is raised of the question of whether the services were fit for the purpose for which they were acquired. A number of arguments have been advanced in support of the proposition that there is no realistic prospect of the claimant establishing that the software provided was not fit for its intended purpose. The first is the question of just how the claimant was able to issue thousands of contracts, invoices and receipts using the software. That raises a question of fact, and the claimant says, in answer to that contention, relies upon a witness statement which gives evidence of the fact that there are features of the software that have been supplied that are unsatisfactory to the claimant. Now, that is a difference between the parties on issues of fact. That is an issue which is preeminently of a kind that requires adjudication by a trial and not on the papers in the course of an application such as this. The second aspect of the claimant's argument on this topic is the argument that the renewal of the software AMC shows that the implementation was successfully completed, and it's said that it's entirely inconsistent for the claimant to have renewed maintenance contracts for the software if it says the software was defective. Again, that is a question of fact. It's an argument properly raised at trial, but it's not an argument of a kind that can be determined on the papers in the course of an application such as this without hearing any evidence. And the next matter relied upon is that there are work done certificates that were signed, which serve as official documentation certifying the completion of work. Again, that raises questions of fact, no doubt at trial. That is an argument that can be advanced, and it will be for the claimant to establish that the services that were provided were not fit for the purpose for which they were required, notwithstanding the issue of those certificates. But that's a matter that has to be determined on the basis of evidence, not summary argument in a case, in an application of this kind. The next matter that's raised in relation to these factual issues is that the issue has only been raised after several years of successful usage, and it's said that if there were difficulties with the services provided, one would have expected those difficulties to be raised much earlier than they were now. Again, that's a question of fact. No doubt that's a question which the first defendant can raise with the claimant's witnesses at trial. But it's not, again, these are all questions of fact which are of a kind that must be determined at a trial rather than on the papers without hearing any evidence. And so for essentially those reasons, all of the issues which are raised by the first defendant in relation to this limb of the argument in support of the application raise questions of fact. They are questions of fact which are disputed. They're not questions of fact which can be determined by me on the papers in an application such as this, and it therefore can't be concluded that the claimant has no realistic prospect of success on its claim. The next matter raised by the first defendant in support of its application is that it said that the matter has been determined by a previous judgment by the Small Claims Tribunal, and that is the case to which I have referred. And I've probably said enough already to explain why, in my view, that decision is not determinative of these proceedings, or at least arguably is not determinative of these proceedings. And of course, I'm making no determinations at this stage. The only question I'm determining is whether there is a realistic prospect of success, not whether the claim will succeed or what arguments will be definitively determined. The argument that the claimant advances is that the matters that were determined by the Small Claims Tribunal were quite different in character to those which are raised in these proceedings. And in particular, it said that the matters that were determined by the Small Claims Tribunal was the operation of the contractual provisions relating to entitlement of a refund in the event that some of the modules were not completed, and the entitlement of the claimant to an order for termination of the agreement. Claimant contends that neither of those matters are raised by these proceedings. To the contrary, What is raised is a claim for damages for breach by reason of the failure of the first defendant to provide services of the quality and character that it was obliged to provide under the terms of the contract. And it's therefore said that there are no determinations of the Small Claims Tribunal which would preclude those arguments being advanced in these proceedings. Now, as I've mentioned, it's not necessary for me to determine that argument at this stage. All I need to assess is whether it is an argument which has a realistic prospects of success, and it seems to me that I can't conclude that the effect of the Small Claims Tribunal decision is such that claimant's current claim has no realistic prospect of success. The next, and I think the final matter raised relates to, or not quite the final, but there's a couple more matters that I'll go through. It's said also that there is the claim lacks prospect of success because the claimant hasn't presented any evidence of direct payments made to the first defendant. Now, again, it's not necessary for me to determine that argument at this stage, but the claimant says in answer to that, that there were three parties to the contract. Under the terms of the contract, the claimant was obliged to pay the second defendant. That doesn't mean that the first defendant didn't have obligations to perform under the agreement, and the extent to which the first defendant derived any benefit from the agreement was essentially a matter between it and the second defendant, not a matter between it and the claimant. As a matter of law, consideration passing from the claimant to the second defendant is sufficient to sustain the promises made by the first defendant and to make those promises enforceable at the suit of the claimant. Again, it seems to me that just looking at the matter from whether this issue raises a complete defence and leads me to conclude that the claimant has no realistic prospect of success, I conclude that it doesn't meet that threshold. Finally, it's said that the witness statement provided by Mr. Bharath Raj should be disregarded because he has only recently been employed. Again, that's a matter of fact, a matter that should be raised in the course of the trial if that is the only evidence that remains in support of the claimant's case at trial. But again, those are essentially issues of fact that are best determined at a trial, not an application of this kind. So for those reasons, I conclude that none of the matters raised by the first defendant in support of its application lead me to conclude that the claimant has no realistic prospect of success on its claim. And for that reason, the application should be dismissed on the merits on the basis that the test, which must be satisfied before immediate judgment can be granted under Part 24.1, has not been established. So for those reasons, the application will be dismissed. Now, Mr. Bajmal, what do you say in relation to the costs of the application?
The costs follow the event, Your Honour.
All right. And in terms of that, they should be either assessed by a registrar if not agreed?
Yes, we agree. Yes, correct.
All right, Mr. Khan, what do you say? Mr. Bajmal says that his client should receive the costs that's incurred in responding to this application. What do you say to that?
From our point of view, I think we have tried and given all the facts towards this case, but we don't have any legal background or support at the moment.
Yes. All right. Well, thank you, Mr. Khan. Mr. Khan, for your benefit, the usual rule in this court, at least, is that the loser pays the winner's costs. You have lost this application. That's not to say you'll lose the trial, but you've lost this application as a result of which the claimant has been put to incur costs in employing its lawyers. And so for that reason, I think it is appropriate to order that the first defendant should pay the claimant's costs of the application to be assessed by a registrar if not agreed. Is there anything else, gentlemen?
Yeah.
Oh, that's all from my side.
Yes, Mr. Bajmal. Nothing else? Mr. Bajmal, you seem to be freezing a bit. In fact, you have frozen.
I think we lost him.
All right. Yes. All right. Well, he might have gone. He might have realised it's all over. Anyway, I don't think there's anything left.
No, he's joining now.
Oh, he's joining back. All right. Mr. Bajamal, you dropped out.
Yep.
Is there anything else?
No, I didn't hear the last few minutes, but I suppose my position is the same on costs.
Yes. Yes. Well, what I ordered when you couldn't hear me, I'm afraid, Mr. Bajamal, was that the orders will be that the application is dismissed and the first defendant will be ordered to pay the claimant's costs of the application to be assessed by a registrar if not agreed by the parties.
Thank
So
you.
those will be the orders, and that completes the hearing. Thank you both for your time and for your assistance.
So
Good
just one
evening.
question I have.
Yes. Yes.
So this relates to the cost of the application and not the lawyer's fee. Is that right?
No, this relates to the lawyer's fees. So the lawyer's fees incurred responding to the application, you'll be ordered to pay them. You've been ordered to pay them, and they will be assessed by the court if you don't agree with Mr. Bajamal about what those costs should be.
Okay.
Okay.
All right.
All right. That concludes the hearing. Thank you, everybody.
Thank you.
Bye.
Thank you, sir. Thank you.
Bye.